Hello and welcome back to Simple Money Podcast, Canada's own personal finance podcast presented in short and informative episodes. I'm your host, Matthew Seawick, also known as the Friendly Financial Coach. Today we're going to take a stroll in one of the darker corners of personal finances. What happens when we finally kick that oxygen habit and pass away? So please consider skipping this episode if you're not currently in the right frame of mind. This episode is not going anywhere and will be waiting for you right when you need it. Also, as a friendly reminder, all notes for today's episode will be available on the show notes website. I'll also include some helpful links and resources on that page as well. Understanding what happens to someone's finances when they pass away can allow individuals to incorporate it in their financial plan. Taking advantage of this knowledge can simplify the process and avoid charges from taxes and probate, which can be quite substantial in some cases. You'll also need the information if you manage an estate as an executor, and you could also help guide others during the process. So we're going to break this topic into 2 episodes. Today, we're going to talk about what happens to your assets and debts at death, and then for the next episode, we'll look at final taxes and how an estate works. During the whole way, I'll also be offering advice on ways to simplify the process and save on expenses. Importantly, this is a complex topic, and it's highly recommended that you speak to a regional professional to guide you with your specific needs. So, the process at death can take many different paths. Your province or territory, amount of assets held, and more will shape the direction of this process. A big consideration is if you have a legal and valid will, and we've talked about this quite a bit on past episodes, but an individual can pass away with or without one. Having a properly made will allows the process to move much smoother than if a person passes away without one, which is called intestate. One of the first things is that a legal representative must be identified. If you have a legal will, this will usually be your executor, possibly plural. And if you pass away without a will, then a legal representative must be appointed as an administrator of the estate by a court. In some cases, spouses, family members, and close friends can provide information to financial institutions, but will often not be able to find out about any confidential information until they are classified as a legal representative. Importantly, if they are listed as a beneficiary or joint with rights of survivorship, then parts of the estate may even be sidestepped, something we'll talk about shortly. You also want to make sure that your executors know that they are listed and that they are comfortable with the process. It's actually quite time consuming and takes a lot of effort, so you want to make sure that the person that you elect is ready and able to take this role. The representative will have quite a few responsibilities, including notifying relevant financial institutions about the death, contacting the CRA and providers of any income, like pensions, and completing your final tax return. After that, they will have to manage your estate. One of the first tasks that the legal representative will have to do is collect as much information as possible. This will include things like details about the assets, including market value at death, debts, and the different types of income sources that are being paid out to the deceased. And sometimes this can be really challenging to find out, especially if the deceased had lots of accounts all over the place. I've witnessed this firsthand, and it can be very hard for them because they essentially are going to every single financial institution in the area hoping to find some account under the individual's name. Now, a good place to find this information is by looking through the banking activity of the deceased to find where their sources of income are coming from or going to, and their past income tax returns with tax slips to see if they have any taxable assets. The representative should contact all sources of income, like pension providers, government departments, and more. If these providers make a payment after death, then these payments will usually have to be paid back. The CRA also needs to be notified about the individual that passed away. As a general tip, if you have someone listed as an executor, you essentially want to leave them some information where all your assets are listed. This would really help out with the process and make sure that your final wishes go as smoothly as possible. So, what happens to the assets? Well, there are actually quite a few different rules when it comes to assets, and understanding how each asset category works is really invaluable. And what we're going to do is we're going to cover some of the most common ones. So, first of all, bank accounts. If the deceased had a bank account with rights of survivorship listed, then the account will generally be passed over to the other account holder as they are now considered to be the legal owner. There are cases where this can be rejected by the courts, but generally this is the case. And this is really the first big trick to avoid estate proceedings and probate, by simply making an account joint with rights of survivorship. Of course, you need to trust the person added to the account as they are now, or they will also be legal owners of the account and have full access to the funds. Now, if there are accounts that are just under the deceased's name, then what happens is that those assets will get shuffled over to the estate. So next down the chain are tax-free savings accounts. This awesome investment vehicle is actually very agile when it comes to estate planning. The key here is to designate a beneficiary or successor. If a spouse is listed as a successor, then the full balance of the tax-free savings account can be transferred into their tax-free savings account, even if they don't have enough contribution room, as it's considered to be an exempt contribution. Instead, if a beneficiary is listed, then they are eligible for a tax-free lump sum payment. However, if the tax-free savings account increases in value after death, then the beneficiary will have to pay taxes on that increased amount. If a spouse is listed as a beneficiary, they can also roll over the balance to their tax-free savings within a specified exemption window. But unfortunately, if they're not listed as successor, they'll still have to pay taxes on the increased amount. And if there are no beneficiaries listed on the tax-free savings, or if the estate is listed, then what will happen is the full balance of the tax-free savings will be paid out to the estate. The process with registered retirement savings plans, RRSPs, is pretty similar as tax-free savings, but it is much more tax heavy. The full value of the RRSP can be transferred over to a spouse and added to their RRSPs. Dependent children or grandchildren can have it taxed in their hands or placed in an annuity until they turn 18. If you have any other beneficiaries that are not a spouse or a dependent child or grandchild, then the process is a little bit more complicated. The full value of the RRSP is taxed on the deceased's final tax return and then paid out afterwards. And we'll talk more about that in the next episode, but this can heavily reduce the amount that is left over to beneficiaries. Again, if no beneficiary is listed on the RSP, then the full balance will be taxed and then added to the estate assets. Although beneficiary information can also be included in the individual's will. So the tip here, and I pretty much say this to everyone, is make sure that you have a beneficiary or successor added to your registered accounts, because that will make the process just so much easier. So other common assets include workplace pensions. The rules here can vary heavily and depend on how the workplace pension was set up and what type of pension it is. In many cases, the rules will also differ if the deceased passed away before they began receiving their pension or after. Here, common outcomes will include a survivor's pension to the spouse or any dependent children, a lump sum payment from the plan, a deferred pension, and more. It's important that you know the rules of the pension and plan accordingly in advance. Now, when it comes to non-registered accounts held just under the deceased's name, those will be payable to the estate, and in some cases can incur taxation. For example, non-registered stocks held just under a single name, under the name of the deceased, are deemed to have been sold at death, with capital gains from that asset being applied to their final taxes. And this can obviously be a fairly large charge. And this is something that we're going to explore more during our next episode. So the next question is, what happens to debt? Well, the legal representative should immediately notify the debt issuer, whom will begin processing the request. If the account is joint, it will usually be transferred over to the other account holder. And if it's just under the deceased's name, then it will have to be settled by the estate. And if there are not enough assets to cover the debt, then the debt is usually considered to have been settled. So a couple big takeaways from today's episode. Number one, do your best to have a will put in place and make sure that it's also legal and up to date. Next up is make sure that you have beneficiaries or successors listed on your registered accounts. And also, if you have a trusted individual, possibly think about adding them on an account with joint with rights of survivorship. All of these can help you bypass the estate and reduce charges, fees, and in some cases, avoid having assets to pay down any debt that the estate may be responsible for. So that's it. Thank you again for listening to Simple Money Podcast. As always, if you have any questions, feel free to email me at info@ffcoach.ca. Keep safe and talk to you soon.